The first thing the judge did was not rule on my father's house. She asked whether I was represented. When I said no, she asked the clerk to stop turning pages and looked at me as if she had been trying to place my face for several seconds. "Ms. Bennett," she said, "have we met before?" I was standing alone at the defense table with a folder pressed against my ribs. Across from me, my Uncle Victor sat beside a lawyer who had spent the first 20 minutes speaking as though the outcome had already been filed, stamped, and mailed. The paper in front of him was called a quitclaim deed. It carried my father's name, a date, a notary block, and a claim that Elias Bennett had transferred our house to his younger brother before he died. I had no lawyer sitting beside me. I had a legal aid appointment scheduled for the following week, but that appointment was only a review of my documents. It was not representation. The private attorneys I had called either wanted a retainer I could not pay or had no opening before the court's deadline. Victor's attorney had already asked the court to keep the property frozen through a notice of lis pendens and a temporary status quo order. No one was going to sell the house that afternoon. But no one was going to let me repair it, distribute the estate, or make decisions about the title either. Taxes and insurance would continue. The roof would continue to age. The bank would continue to send notices addressed to a man who was no longer alive. The house would remain caught between my father's death and my uncle's version of what my father had intended. "Have we met?" the judge asked again. I searched her face. I recognized nothing except the controlled patience of someone used to people answering difficult questions under pressure. "Not that I remember, Your Honor." Something changed in her expression. Not warmth, not surprise, recognition, followed immediately by caution. She looked down at the deed, then at the file, then back at me. "7 years ago," she said, "were you driving on Route 35 during the flood?" My hand tightened around the folder. Rain, a crushed sedan, a woman's hand reaching through broken glass, a promise I had made to a stranger because she was afraid and I was the only person close enough to hear her. The memory came back in flashes, but the woman in the car had not looked like the judge sitting in front of me. She had been pale, soaked, and terrified. I had never learned what happened to her after the ambulance doors closed. I said. The judge inhaled slowly. "Then I need to disclose a prior personal encounter before this matter goes any further." Victor's attorney stopped writing. The judge explained that she had been the person trapped in the car that night. I had stayed with her until emergency crews arrived. She remembered my voice. She remembered my refusal to leave. She had not known my last name until the case file appeared in front of her. She also explained what that recognition meant. "Because I remember you personally," she said, "I cannot preside over a property dispute in which you are a party. I will recuse myself before taking evidence or making any decision on the merits." Victor shifted beside his attorney. I wanted to feel relief, but the judge had not helped me. She had not looked at the deed and declared it false. She had not told the clerk which exhibits to accept. She had not even asked why I was standing there without counsel. She was stepping away because fairness required her to. The clerk recorded the recusal. The existing status quo request remained in place for 14 days while the case was reassigned. A new judge would set disclosure deadlines and hear the evidence later. "The court is not deciding ownership today," the clerk said. That sentence should have comforted me. Instead, it made the wait feel like another kind of danger. Victor's lawyer closed his folder. "We will need time to transfer the record," he said, "and we ask that the title remain protected during that period." The request sounded reasonable. That was what made it frightening. When I walked out of the courtroom, I still did not know whether my uncle had a valid deed. I only knew that a judge remembered me from a night I had forgotten. My father's house was locked inside a legal dispute, and the document Victor carried had been prepared with enough confidence to make a room full of strangers treat it as possible. I had come to court expecting the paper to decide everything. Instead, the paper had opened a question. 3 months earlier, I had stood beside my father's grave and listened to rain tick against the black fabric of my umbrella. Elias Bennett had died quietly after years of heart disease. He was 66, stubborn about doctors, generous with tools, and convinced that every problem became more manageable once it was written down in the right notebook. He had spent most of his life in the same Dayton house. It was not large or expensive. The paint on the porch railing had peeled in strips. The kitchen cabinets were older than some of my childhood memories. In the basement, his workbench was arranged with such precision that I could find a Phillips screwdriver without turning on the overhead light. My mother had died years earlier. After that, the house became the place where Elias stored every version of his life with her. Her blue mug remained on the second shelf. Her recipe cards stayed beside the refrigerator, even though he cooked from memory. The porch light was always left on when I was deployed. "Come home," he used to write in his messages. "I will leave the light on." His will was simple. The house would pass to me. His tools and accounts would be divided among the family, according to a list he had revised twice. Victor would receive a small investment account and several pieces of equipment. Victor had helped Elias over the years. He had repaired the roof once, replaced a furnace motor, and spent several weekends rebuilding the back steps after my mother died. I had never questioned whether those contributions mattered. They mattered to Elias. He spoke about Victor with a mixture of gratitude and frustration that I had understood as ordinary family history. After the funeral, Victor began asking questions. Who had the original deed? Had I decided whether to keep the house? Was the estate administrator finished with the inventory? At first, I answered him. Then his questions became more specific than my answers deserved. "Dad told me we would work something out," he said one afternoon in the kitchen. "About what?" He looked toward the hallway where the framed photograph of my parents still hung. "The property." I thought he meant repairs. I told him I would review everything with the administrator. He smiled, but the expression did not reach his eyes. The certified will and the official title records were with the probate administrator. Bank records were being released by the bank. Business files remained at the repair shop until the estate inventory was complete. Nothing was being hidden in one convenient box. The process was simply moving more slowly than grief wanted it to. During the administrator's photographed inventory of the house, I noticed a small metal case locked inside Elias's office cabinet. "That goes into the inventory," the administrator said. "Once the catalog is complete, you can open it in my presence." I nodded. I did not know what was inside. I only knew that Elias had kept it separate from his ordinary files. At the time, I believed the most difficult part of losing my father was learning how to walk through the house without calling him. I had not yet seen the quitclaim deed. I had not yet learned that my uncle believed the years he had spent helping Elias had created an ownership claim. And I had not yet understood that a house could become evidence before it stopped feeling like home. The administrator's name was Calvin Reed. He was not cold, but he had the careful manner of a person who had seen families mistake urgency for permission. At our first inventory meeting, he placed a printed list on the kitchen table. "The estate has 3 categories of records," he said. "Official probate documents, financial records released by institutions, and personal or business materials that still need cataloging. When do I get the official file?" "You can review the certified will in my office. The original deed history will come from the county recorder. The bank will release statements after it verifies the estate account. The repair shop records will be cataloged separately." "And the metal case?" "It is personal property. I want it photographed and listed before it is opened." I understood the reason. I did not like the delay. Grief made every unopened drawer feel like a locked door someone had chosen to put between me and my father. Calvin noticed my expression. "This is not a judgment about you," he said. "If a dispute develops, every item becomes something someone can say was altered, removed, or misunderstood. The inventory protects you, too." I signed the inventory sheet. That afternoon, I visited the county records office and requested the title history for the house. The clerk told me the most recent recorded instrument was still in Elias's name. That did not prove the quitclaim deed was false. An unrecorded deed could still matter. But it meant Victor's filing was asking the court to treat a document as a transfer before the public title record had changed. At the bank, I learned that Elias had paid the property taxes through the year of his death. Victor had not paid them. He had paid for the furnace motor and part of the back steps. The distinction was ordinary and uncomfortable. Victor had helped. He had not done everything he claimed. I wrote each item in a notebook with 2 lines beneath it. What this proves, what this does not prove. The habit felt mechanical until I realized it was also keeping me from turning every discovery into a verdict. Victor came to the house once while the inventory was underway. He stood outside the kitchen window until I opened the door. "Calvin says I have to wait for copies," he said. "Everyone has to wait. You have the house." "I have a claim to the house. That is different." He looked past me at the empty dining room. "Your father told me not to worry about the property." "Did he say he was transferring it to you?" Victor's mouth tightened. "He said I would be taken care of." "That can mean a lot of things." "Not when you have spent 20 years being the person who shows up." I wanted to say that I had shown up too, even if military assignments and distance made my presence look different. Instead, I asked him to leave the inventory to Calvin. He did, but not before looking toward Elias's office. That was when I understood that Victor was not waiting for the same answer I was waiting for. I was waiting to learn what my father had left. Victor was waiting to see which parts of my father he could still claim. The notice arrived in a white envelope with the court seal printed across the corner. Victor's attorney had filed a claim against the estate. Attached to it was the purported quitclaim deed. It stated that Elias had transferred the house to Victor on March 14, 2024 at 3:15 in the afternoon in the office of Patrick Vance, a licensed notary. If the deed was valid, the house had left my father's estate before he died. His will would not control property he no longer owned. That was the first legal point Lena Ortiz explained to me during our one-time consultation at the legal aid office. "People often think a will answers every ownership question," she said. "It answers what remains in the estate. The first question here is whether this property remained there." I set the document on her desk. My father's signature was at the bottom. It looked like his signature. That frightened me more than a badly forged line would have. "Do you know the date?" Lena asked. "I know he was in the hospital around then. I need the records." "Good. Start with what the deed claims: date, time, place, named notary, and the provenance of each page. Don't begin by calling it a forgery. Begin by checking whether it could have happened as written." She was not representing me. She explained that the organization could review selected evidence and might accept limited scope representation if the case developed a clear procedural need. For now, I was responsible for gathering records and meeting the court's deadlines. Private attorneys had quoted retainers that exceeded the money I had set aside for the house. One could not take the case for months. Another told me property disputes became expensive because every document created a new question. Victor's filing requested a notice of lis pendens and a temporary status quo order. The request would keep the title from being sold or transferred while the court considered whether the deed was real. No one was going to force a sale that week, but the restrictions meant I could not make normal decisions about the property. The insurance renewal was due, the basement needed a dehumidifier, a section of the roof had begun to leak near the back stairwell. The cost did not stop because the title was disputed. Victor sent a proposed settlement through his attorney. The language was calm. He would waive part of his repair claim if I granted him a small ownership interest and agreed that neither side would pursue further costs. It was not an outrageous offer. It was the kind of proposal someone could describe as practical. But one paragraph required me to release every challenge to the quitclaim deed. I read it twice. "You don't have to decide today," Lena said when I showed it to her. "If I sign it, I can't ask whether the deed is valid. That is what the release is designed to do." I looked at the photograph of my father on the wall behind her desk. He was standing in the basement with a paintbrush in one hand and a look of irritation that had always meant he was trying not to laugh. "Then I can't sign it today." The deed included Teresa Hall's signature on a purported attestation page. She had worked in Victor's office. I knew Teresa only by name. I had never met her. The court date was set before the next legal aid appointment. That was how I ended up standing alone in a courtroom with a folder of records and a document that claimed my father had given away the house I had spent my life calling home. The petition described the deed as the final expression of Elias's intent. It attached photographs of the house, invoices for repairs, and a statement from Victor saying that he had maintained the property when I was away. The photographs were accurate. The invoices were not entirely false. That combination gave Victor's argument a surface I could not dismiss with anger. He had replaced the furnace motor. He had paid a roofer after a storm. He had helped Elias move the workbench when my father injured his shoulder. But the invoices did not say he had bought the property. They said he had paid for work. The distinction seemed obvious until I read the paragraph in the petition that described every payment as part of an understood arrangement. There was no written arrangement. The word understood did a lot of work. It asked the court to turn years of family assumptions into a legal transfer. I called one of the attorneys who had declined the case. He listened while I described the deed's date and the hospital admission. "Request the original," he said. "Do not rely on a scan if the question is how the pages were assembled. Preserve every version you receive." "Can the court reject it now?" "Not because you say the signature looks wrong. The court will want a process. Who signed it, where, when, in front of whom, and under what authority?" I wrote those questions beside the 4 columns on my dining room table. The first court filing also included a statement that I had been absent from Ohio for most of the final year of Elias's life. It was true that I had been away for work and transition. It was not true that I had abandoned him. I had called every Sunday. I had sent money for his cardiac rehabilitation. I had flown home twice when his symptoms worsened. Victor's attorney did not need to accuse me of being a bad daughter. He only needed to make the court wonder whether my father had trusted Victor more because Victor had been physically present. That was the emotional argument beneath the legal one. I could feel it working on me. For 2 nights, I considered whether I had misunderstood my father too. Maybe he had promised Victor a share and never told me because he knew I would object. Maybe the deed was authentic, and the hospital record only meant that Elias had signed before or after the listed appointment. Maybe I had come home prepared to defend a decision my father had already changed. Then I looked at the deed again. A valid transfer did not need my anger to survive. It needed a date, a place, a credible acknowledgement before the named notary, and pages whose provenance could be established. That was what I would test. After Naomi Brooks recused herself, the clerk explained the immediate procedure in a voice that sounded almost bored. The 14-day status quo order would remain while the case file moved to another judge. Neither side could sell, transfer, or distribute the disputed property. Both sides would exchange the documents they intended to rely on. A new judge would set the evidentiary hearing. That was all. There was no secret signal in the judge's disclosure. No suggestion that I had been right. no warning that Victor had been wrong. Outside the courtroom, Victor's attorney asked for the ordinary time needed to transfer the record and prepare the new judge. He did not demand an indefinite delay. He did not tell me to settle before anyone looked closely. He said the title needed to remain stable while both sides exchanged records. The request was legally ordinary and personally exhausting. The clerk gave me a new calendar with the reassignment date circled. I wrote down the disclosure deadline, the date the status quo order would expire, and the names of the offices that still owed us records. The case had changed judges, but it had not changed its demands. I still had to prove each fact without asking the procedure to feel sorry for me. Victor approached me near the elevators. "This is going to cost both of us," he said. "Then stop claiming the house." His face tightened. "You still think this is about stealing from you? You filed a deed saying Dad gave you the house." "I filed what I was given." It was the first time he had used that phrase. Not what I signed, not what your father gave me, what I was given. The sentence stayed with me as I left the courthouse. The new judge set the evidentiary hearing 6 weeks later. The disclosure deadline was sooner. I had 14 days before the status quo order needed to be renewed or replaced, and I had 6 weeks to determine whether the deed could survive a precise review of its date, time, place, Notary Act, and attestation page. The recusal had not given me a victory. It had given me a schedule. I taped that schedule beside the refrigerator. The first column held deadlines, records, disclosures, status quo renewal. The second held practical problems, insurance, roof, utilities, the administrator's inventory. The third held questions I was not allowed to answer by instinct. Who had touched the page? What did the notary actually deny? What would the will control if the deed failed? Seeing the questions together made the case feel less like a family curse and more like work I could do one piece at a time. The schedule did not make the work easy. It made the next task visible. I could not postpone every decision forever, but I could choose the next one. 7 years earlier, I had been driving home from a training assignment when the rain became too heavy for the highway to feel real. Water rushed across Route 35. Headlights dissolved into pale streaks. I slowed until the cars around me became shapes moving through gray darkness. Then I saw the sedan. It had struck the concrete barrier and spun sideways across part of the road. Hazard lights blinked behind it. I pulled over, called emergency services, and ran toward the driver's side window. A woman was trapped inside. She was conscious, but the door had collapsed against her. Her breathing came in short, frightened bursts. "Please, don't leave me." "I'm not leaving." I said it because she needed to hear it. Then I kept talking so she would have something to follow besides the sound of the rain. I asked her where she lived. I asked whether she had children. I told her the firefighters were coming. I told her to keep looking at me. When the rescue crew arrived, they cut through the door and lifted her out. She reached for my hand once before the paramedics closed the ambulance doors. "What's your name?" she had asked. "Mara." "Mara what?" I had smiled. "Just Mara." I never learned her name until the judge said it in court. Naomi remembered a woman who had refused to leave. I remembered an emergency I thought I had finished the moment the ambulance drove away. The difference between those memories mattered. I had treated the night as a fact filed away in my past. Naomi had carried it as proof that a stranger could remain when remaining was difficult. I wondered whether I had stayed because I was brave or because there had been no time to be afraid. The distinction mattered less than the choice itself. In the flood, I had not known the woman, her history, or what she might later say about me. I had only known that leaving would make the danger worse. That was the part Naomi had remembered, not a debt she could repay. It explained why she recognized me. It did not explain the quitclaim deed. For a few minutes after I remembered the crash, I wanted the recognition to mean more. I wanted Naomi's memory to be a kind of promise that the courtroom would not let another person rewrite what had happened. Then I pictured her disclosure form and the clerk's careful voice. Naomi had done the only fair thing available to her. The rest would have to come from records. For that, I needed a timeline. I made the timeline on the dining room table because Elias had always said important facts should be visible from more than one angle. I divided a sheet of paper into 4 columns: what the deed claimed, what another record showed, what the conflict could prove, what it could not prove. The deed claimed that Elias had signed at 3:15 p.m. on March 14, 2024, inside Patrick Vance's notary office. It carried Patrick's notary information and included an attestation page with Teresa Hall's signature. The language sounded formal enough to make my stomach tighten. The first record I requested was the hospital admission file. Elias had been admitted on March 13 after a cardiac episode. The nursing notes placed him in monitored care from 2:40 p.m. through 5:10 p.m. the next day. The record did not say he could never hold a pen. It said he was in a monitored cardiac unit at the time and place stated on the deed. That distinction mattered. I wrote it in the 4th column. The record could contradict the deed's claimed location. It could not, by itself, identify who prepared the document. The second request went to Patrick Vance. I did not call him and accuse him of lending his name to a false deed. Lena helped me prepare a written request through the appropriate channel. We asked him to preserve the journal entry, office calendar, and any record showing whether he had performed notarization for Elias Bennett. Patrick's office replied through a staff member first. They confirmed that the office had been closed from noon on March 14th until the following morning because Patrick's wife had suffered a medical emergency. The building log showed the front door had not been opened after 12:13. That information made the deed look worse, but Lena still cautioned me. A closed office and a hospital record are powerful together, she said. They don't authorize you to claim you know who created the deed. What would authorize that? A chain. Someone who handled the page, a message, an instruction, something that connects the unreliable instrument to a person, not just to a problem. I wrote that down. Victor had contributed labor to the house. He had paid for 2 small repairs himself, and Elias had reimbursed him for one. The bank records did not support Victor's claim that he had financed the roof, furnace, and property taxes, but they also did not prove he had never helped. That was important too. If I turned every disagreement into a lie, I would make the case easier for Victor's attorney to dismiss as grief. Victor sent another settlement proposal before Patrick's journal was released. This one offered a larger amount and described the quitclaim deed as a family document that may contain technical imperfections. Technical imperfections. I read the phrase several times. He is preserving more than one legal position, Lena said. For what? For the document to be challenged without conceding what the challenge means. The status quo order was still in place. The roof still leaked. The insurance company still wanted a decision about an empty house. My savings were shrinking around a property I could not legally control. I could have accepted the offer and called it peace. Instead, I declined it. Abroad. The next morning, Lena agreed to review the evidence on a limited basis. She would help me identify what to request and how to preserve it. She would not take over every part of the case. For the first time, I felt the difference between being alone and being unsupported. I was still responsible for the work, but I no longer had to pretend I understood every rule by myself. The hospital records arrived as a secure PDF with a certification page. I printed them at the library because the printer at Elias's house had stopped working. The pages smelled faintly of warm toner, and I spread them across the table in order. Admission, March 13th, 8:17 p.m. Cardiac observation, March 14th, beginning at 2:40 p.m. Medication administration, 3:05 p.m. Nursing note. Patient resting under continuous monitoring. No visitors recorded between 2:30 and 4. The deed said Elias had been at Patrick's office at 3:15. The problem was no longer that I could not imagine my father signing a document in the hospital. The problem was that the deed described a different place, a different setting, and a notary act that Patrick denied performing. Lena made me read the distinction aloud. "The records show the deed was not executed as written," I said. "Good. Now say what they do not show." "They do not show who assembled it." Again. "They do not show who assembled it." That sentence will protect you from making an accusation you cannot support. I disliked the sentence because it made the investigation slower. I also understood why I needed it. We prepared a preservation request for Patrick's journal, office calendar, seal records, and any mobile notary log. Lena explained that a phone call from me could be remembered as pressure, while a formal request created a record of what we had asked for and why. The county records clerk also explained that the deed had not been recorded. Victor's attorney had filed a notice of lis pendens to alert anyone searching the title that a dispute existed. The deed itself was being offered as evidence, not as a cleanly recorded transfer. That detail changed the way I understood the first hearing. Victor was not asking the court to rubber stamp a public record. He was asking the court to decide whether a private document should alter the estate's title history. That meant the burden of careful examination mattered. It also meant the question of Teresa's signature was not a side issue. If the attestation page had been moved from another packet, the court needed to know how and when. I called Teresa's former employer, only to verify her last known address. The office manager would not discuss her, but he confirmed that Teresa had handled vendor paperwork and that Victor had supervised the department during the period described in the deed. I wrote her name beneath the notary's name. Two people were connected to the document in different ways. One denied performing the official act. The other might explain the signature page. The timeline was no longer a list of dates. It was becoming a map of access. The payroll record placed Teresa Hall at Victor's office for almost 9 years. Her last recorded day was 6 months before Elias died. I sent a letter to the address listed in the record. I explained that I was not asking her to choose sides. I was asking what she knew about one signature page. She called me 2 evenings later. "I saw your name on the letter," she said. "I wondered when this would come back." Her house was a small brick ranch on the edge of town. She kept the porch crowded with potted herbs and apologized for the smell of paint in the hallway. "I am not here to accuse you," I said. "That is what people say when they are trying not to scare you." "Then I will be precise. The deed filed by Victor's attorney has your signature on a purported attestation page. Did you sign that page?" Teresa looked toward the kitchen. "I signed the page," she said. "I did not witness your father sign a deed." She brought out a thin folder from a desk drawer. Inside was a scanned copy of a vendor authorization packet from Victor's company. The page with her signature was attached to a form authorizing a contractor to receive equipment on behalf of the business. The signature was the same. The placement was the same, but the page filed with the quitclaim deed had been moved to a different packet. The header was missing. The page number did not match. The initials in the lower corner had been cropped. "Why did you sign it without reading everything?" I asked. She did not become defensive. "Because I had worked for Victor for years. Because he put it in front of me at the end of a long day and said it was routine. Because people make mistakes when they trust someone who has been familiar for too long." She had signed the standalone acknowledgement page at Victor's office. She had returned the vendor packet to him. She had never seen Elias there. She had never been asked to stand beside him while he signed anything. "Did you keep the scan?" "I scanned the packet from my own records. I had started doing that after a billing dispute." That scan gave us a comparison, but not yet a direct connection to Victor's use of the page. Teresa opened an old email account on a laptop that took several minutes to start. She searched for Victor's name and found a message chain from the month after Elias's hospitalization. The first message was ordinary. "Can you send me the signed vendor page again? The equipment company needs it." The next message arrived 2 days later. "Not the whole packet, just the signed page. I need it for the house papers." Teresa had replied with a question. What house papers? Victor had not answered in writing. He had called her. "I thought he meant the property tax file," she said. "He was always mixing business and family paperwork." "Did you send the page?" "I sent a copy because I still had the scan. I did not know he was going to attach it to a deed." Her voice changed on the last sentence. She had not signed a blank page. She had not watched Elias sign. But she had returned a signature page because Victor asked for it and because she trusted him enough not to ask why a vendor acknowledgement was needed for a house. That mistake gave Victor an opening. It did not make Teresa responsible for the deed. It made her the person who could explain how her signature got there. "Will you give a statement?" I asked. She looked at the scanned packet. "If I do, Victor will say I am trying to save myself." "Maybe he will." "And what will you say?" "That you signed a page without understanding how it would be used. Both things can be true." She sat quietly for a moment. Then she agreed to meet Lena and provide the email export through a method that preserved the original information. On the drive home, I thought about the way betrayal rarely arrived as one dramatic act. Sometimes it arrived as a familiar person asking for one page, one favor, one signature, one assumption that would be harmless if it remained inside the relationship. The page had left Victor's office as a vendor acknowledgement. It had returned as part of a deed claiming my father had given away his home. For the first time, the false document had a mechanism. It still needed to survive the notary. Before we left Teresa's house, Lena asked her to walk through the sequence one more time without looking at the deed. "Where were you when you signed the original page?" "At Victor's office." "Who was present?" "Victor, me, and a delivery driver who came in near the end." "Was Elias present?" "No." "Did Victor say the page was for a property transfer?" "No, he called it a vendor acknowledgement." "When did you first see the quitclaim deed?" "When his attorney mailed me a copy after the court filing." Teresa's answers were not dramatic. That made them more useful. She could not tell the court who created the deed file. She could tell the court that the page had existed in another packet, that Victor requested a copy after Elias was hospitalized, and that she had never witnessed the act the deed claimed she had witnessed. On the drive back, Lena explained why Teresa's willingness to admit uncertainty could become part of her credibility. "You made a mistake," she said to Teresa. "You do not need to make yourself innocent of every mistake in order to be truthful about the larger use of your signature." Teresa stared out the passenger window. "What if the judge thinks I was careless?" "The judge may think you were careless. The question is whether your carelessness proves Victor had permission to use the page for anything." At home, I compared the two documents line by line. The signature page was not a photocopy pasted into the deed. It was a clean scan placed between the deed's second and fourth pages. The crop removed the vendor header and internal code but left a sliver of a black line near the edge. That sliver appeared on the scan Teresa had saved. It was small enough that no one would notice unless they were comparing the pages side by side. I circled it in pencil. The deed had not only used Teresa's signature, it had used a page that had once belonged somewhere else. That did not tell me whether Victor had personally edited the packet. It told me the document had a history outside the courtroom, and that history could be traced if we did not let anyone reduce the page to a mysterious signature at the bottom of a formal sheet. Patrick Vance agreed to meet at a conference room used by the county records office. He arrived carrying a gray binder and the tired expression of someone who had been forced to revisit an event he had never been part of. Lena asked the first questions. "Did you notarize a quitclaim deed for Elias Bennett on March 14, 2024? No. Did you affix the notary seal shown on this document? No. Patrick turned the deed toward himself without touching the signature block. That is not my act. He opened the journal. The entries around March 14th were clear. There was no Elias Bennett, no property transfer, no signature matching the deed. He also provided a copy of the office calendar and the building log. My office was closed that afternoon, he said. My wife was in the emergency room. I did not perform mobile notarizations that day. That last sentence closed the explanation Victor's attorney might otherwise have used. The deed did not merely lack an entry. The notary whose name appeared on it denied performing the act, denied affixing the seal, and had a contemporaneous record showing his office was closed. Still, Lena did not celebrate. This establishes that the deed was not notarized as represented, she told me afterward. Teresa's message is the separate link to Victor. Do not make one fact carry the entire case. Victor's attorney filed a motion accusing me of harassing witnesses and manufacturing a case out of grief. The words hurt because they were designed to sound reasonable. The new judge set boundaries. Teresa would communicate through counsel or the designated process. Both sides would preserve original files. No one would contact Patrick privately about the substance of his testimony. Victor's attorney presented an alternate theory during the hearing on the motion. The deed may contain a clerical error, he said. It is possible Mr. Bennett signed a draft somewhere else. It is possible Ms. Hall misunderstood the use of her page. It is possible the notary block was attached by an office employee without Mr. Morgan's knowledge. It was not a pleasant theory, but it was a theory. It gave the court something to test, instead of a villain to condemn. Lena explained the next procedural change to me. The legal aid organization will accept limited scope representation for the evidentiary hearing, she said. I will handle the examination and the procedural submissions. You will still need to provide the estate history, identify the records, and testify where you have personal knowledge. So you are not taking over everything? No, I am making sure the evidence is presented correctly. That is different. The distinction relieved me. I had not wanted a miracle lawyer to arrive and erase the part of the story where I had been afraid, confused, and responsible for learning. I wanted help that did not pretend the work had never been mine. The motion hearing took place in a smaller courtroom. Victor's attorney argued that my requests had burdened ordinary people with a family dispute. He described Teresa as an anxious former employee and Patrick as a notary trying to protect his license. He suggested that my insistence on comparing pages was a form of harassment. Lena did not respond by calling him dishonest. She showed the court the written requests. They were limited to preservation, identification, and scheduled statements. I had not gone to Teresa's workplace. I had not contacted Patrick's wife. I had not posted the deed online. The judge asked both sides to use formal channels. The court will not permit private pressure on witnesses, she said. It will also not treat a request to preserve records as harassment merely because the records may be inconvenient. That sentence applied to me and to Victor's side at the same time. Afterward, Lena drew a simple diagram on a legal pad. The deed was at the top. Under it, she wrote 4 questions. Did Elias sign it? Was it notarized? Did Teresa witness what it says she witnessed? Who obtained or moved the signature page? If we answer the first 3, she said, the deed may fail, even if the 4th remains disputed. Then why do we need the 4th? Because the court is not a machine. It will want to understand how the document came to exist, especially if costs or a referral are requested. But responsibility for the deed and validity of the deed are related questions, not identical ones. That distinction made the case feel less like a hunt for a single villain and more like an examination of a system that had allowed one person's assumption to become a legal instrument. The status quo order continued for another 14 days while the new judge reviewed the disclosures. I made a budget on the back of an envelope. Insurance due in 12 days. Taxes due in 21. Roof repair not affordable until the title restriction ended. Legal aid administrative costs uncertain. The numbers did not make me heroic, they made me tired. That was why the midpoint choice mattered. I was not continuing because I enjoyed the investigation. I was continuing because accepting a partial ownership settlement would turn an untested deed into a permanent part of the house's history. The status quo order continued. Taxes and insurance accumulated. The roof leak spread along the back stairwell. Victor's attorney offered another cost of litigation compromise, but this time the offer included a small ownership interest rather than a clean buyout. The house would remain partly his, the letter said, in recognition of the work he had performed. I had already learned that recognition and ownership were not the same thing. I rejected the offer. The hearing was 6 weeks away. I would not be able to keep the house in perfect condition while the title was frozen. But I could keep the evidence from being rearranged around me. Once the home inventory was complete, the administrator photographed the metal case again and gave me permission to open it in the presence of a witness. The case did not contain a second legal universe. There was no hidden deed that solved the title question. No perfect letter that made the judge's decision inevitable. There were old photographs, a handwritten note addressed to me, and a small digital recorder with a cracked plastic cover. I recognized the recorder. Elias had used it years earlier to record repair measurements when his hands were occupied. He trusted paper, but he trusted a recording when he needed both hands to work. The note was brief. Mara, if Victor ever tells you that helping me made him the owner of this house, remember that gratitude is not the same as a transfer. I am grateful for what he did. I am still allowed to decide what belongs to me. I had to stop reading. Lena listened to the recorder with me in a small office at the legal aid organization. The original file was copied according to their preservation procedure. The first minute contained the scrape of a chair and Elias clearing his throat. Victor's voice came next. You know what this house could do for me. It is not yours to use as collateral. I have kept this place standing. You have helped me. I have paid you for work. I have thanked you for the rest. Victor laughed once, but there was no humor in it. You will leave it to her after everything? I will leave what is mine according to my decision. The recording continued for several minutes. Victor talked about the equipment loan he had guaranteed and the business debt that followed. He said the house could clear everything. Elias refused. He said he would not turn Mara's inheritance into Victor's emergency fund. The recording ended with Elias saying that helping families should not become a private claim against them. Lena removed her headphones. This gives motive, she said. It tells us what Victor wanted and what Elias refused. It does not prove who assembled the deed. The other evidence has to do that work. Can it be used? Possibly after foundation, but we should not build the case around it. I understood why. The note gave me comfort because it sounded like Elias. The recording gave me anger because it sounded like Victor under pressure. Neither one could replace a dated record or a person willing to say exactly what they had seen. If the recording became the only reason the deed failed, Victor could argue that the court had been moved by emotion. The deed needed to fail because its own execution facts did not hold together. I logged the recorder's condition, where it had been found, who had witnessed its opening, and every copy made afterward. Then I listened to Elias's voice one more time. He had not asked me to punish Victor. He had asked me to remember the difference between help and ownership. That difference had become the center of the case. Before we closed the file, Lena asked me to describe the recording in one sentence without using Victor's name. I tried twice and failed. The first version became an accusation, the second became an excuse for him. The sentence that survived was simpler. Elias had acknowledged help, refused a transfer, and made his decision about the house clear. The recording could support that sentence. It could not carry the rest of the case. Teresa's archived message was authenticated through the original device and an export prepared with the help of the legal aid organization's technical staff. It showed Victor asking for the signed page after Elias's hospitalization began. Not the whole vendor packet, just the signed page. Then, in a later message, he wrote that he needed it for the house papers. Victor's attorney argued that the phrase was vague. It could have meant tax paperwork, insurance paperwork, or a document Elias had authorized before his hospitalization. That was true. The message did not prove every step of document fabrication. It did something narrower and more important. It showed that Victor had requested a signature page from Teresa for a purpose connected to the house, even though the page originally belonged to a vendor authorization packet. I kept the two messages beside the vendor scan and did not write forgery across the top. I wrote the questions Lena had taught me to ask. What was requested, what was sent, what was later attached, and which parts still required testimony. The chain became stronger when I left its unanswered spaces visible. Earlier, Victor had asked Elias for an ownership share. Elias had refused. Victor had begun describing repair work as a debt rather than a contribution. When his business debt became urgent, the idea of being owed turned into the need to make the claim look formal. The evidence did not require me to decide whether Victor had thought of himself as a criminal. It required the court to decide whether the deed presented as a notarized transfer could be treated as a valid instrument. Lena made the distinction clear in the hearing preparation meeting. "We can show the deed was not executed as represented," she said. "We can show Victor obtained the page. We can show motive. If another authority investigates document misconduct, that authority will decide whether the evidence meets a different standard." I nodded. For the first time, the story of the deed had a beginning, a mechanism, and a consequence. It had started with Victor believing repair work gave him an unpaid claim. It had moved through a request for one familiar signature page. It had become a deed that could not survive the exact time and place written on its face. The only question left was whether the court would keep those facts separate long enough to see how they connected. I prepared my own testimony on index cards. On one card, I wrote what I had personally seen. On another, I listed what the record showed. On the last, I wrote what I wanted to be true, but could not prove. I left that card blank during rehearsal. The blank space was uncomfortable, but it kept me from turning grief into evidence. By the third week of the status quo order, the house had become an expense I could see from every room. The insurance company required a new inspection. The roof leak had stained the ceiling above the back stairwell. The property taxes were due, even though the estate could not distribute funds connected to the disputed title. I took 2 extra contract jobs, organizing shipping records for a medical supplier. The work was familiar, but the hours left me arriving at Elias's house after dark, carrying groceries in one hand and a folder of court documents in the other. Victor's attorney sent a final settlement proposal. This one was not insulting. It was not written like a threat. It offered to waive Victor's claim for reimbursement of certain repairs if I granted him a small ownership interest and agreed that neither side would seek costs. "It is a rational compromise," the letter said. I believed that the lawyer believed it. That made the choice harder. If I accepted, the title dispute would end. I would have enough money to repair the roof. Victor would receive something that could be described as recognition for the work he had performed. My father would not be able to explain whether he had ever promised Victor anything, because my father was dead, and the house was trapped inside a court file. I brought the offer to Lena. "What would you do?" I asked. I would ask what you are buying with the settlement, she said. Time. And what are you giving away? Ownership. Then it is not only a cost of litigation decision, it is a title decision. She did not tell me to fight. She did not tell me to forgive. She put the question back where it belonged. I met Victor in the parking lot behind his repair shop because I did not want him inside the house. He looked thinner than he had at the first hearing. The confident impatience was gone from his face, replaced by the exhaustion of someone who had been awake with the same argument for too many nights. Dad would have wanted peace, he said. Peace is not the same as giving you the property. You think I wanted to steal from him? I think you filed a deed saying he signed at a place and time where he could not have signed it. Victor looked away. I thought he owed me something. You told him that. He told me to keep helping and he would make it right. Maybe he meant he would pay you. He paid me for jobs. He never paid me for being the one who stayed. The sentence revealed the wound beneath the claim. Victor believed that the family had measured his value in invoices while measuring mine in love. I understood the feeling without accepting the conclusion. You could have asked for a share, I said. I did. He said no. Victor nodded. For a moment he looked like my uncle again rather than the man across the courtroom. Then he said, I thought the house was the only way anyone would admit I had been part of the family. Your father said no. He said no to the house. He did not say no to everything I had done. He rubbed his hands together. I am not asking you to believe me. I am asking you to understand that I did not wake up one morning planning to become this person. People usually become that person one decision at a time. He did not argue. I went home without accepting the settlement. The next morning, Lena prepared the hearing plan. Teresa would explain the original vendor packet and the message. Patrick would explain the missing Notary Act, the closed office, and the seal. Certified hospital records would establish Elias's location. The recorder would be offered only after its chain of custody was clear, and only for the limited purpose of motive and context. The new judge confirmed that the hearing would decide the deed's validity, the title status, and allowable costs. It would not become a trial about every family injury Victor and Elias had carried since childhood. That boundary gave the case shape. It also made the coming day feel closer. The night before the hearing, I sat in the empty living room and rehearsed the questions Lena had given me. Where were you when the estate inventory began? What did you personally see? What did you learn from a document? What are you asking the court to decide? The last question was the hardest. I wanted the court to say Victor had betrayed my father. I wanted it to explain every lie, every private conversation, every time Victor had looked at me and acted as though I were an intruder in my own family. The court could not do all of that. It could decide whether the quitclaim deed transferred title. It could determine whether the restriction should remain. It could address costs and refer suspected misconduct. The rest belonged to the conversations no judge could conduct for us. Lena called at 8. Patrick confirmed he will bring the original journal, she said. Teresa will testify. The message export has been preserved. The recorder is ready, but remember its limited purpose. Motive and context. Exactly. What if the judge thinks Victor did not assemble the deed himself? The deed can still be invalid. What if the judge thinks Elias intended to transfer the house even if the deed is defective? Then the court will examine what evidence supports that intent. Your father's will, the title history, and the record of what he actually signed all matter. She paused. You are not required to win every argument tomorrow. You are required to tell the truth about each fact. After the call, I walked through the rooms. The house held two versions of my uncle. One was the man who had fixed the back steps after my mother died. The other was the man who had asked Teresa for a page and allowed it to appear beneath my father's name. I could not make them become the same person by choosing only the version I missed. The hearing would not decide whether Victor had ever loved his brother. It would decide whether he could use that history to take the property. The courthouse smelled like wet coats and old paper when the evidentiary hearing began. I arrived with a dated, tabbed folder and Lena beside me. Across the aisle, Victor's attorney arranged his exhibits with quiet efficiency, ready to make every uncertainty matter. The judge reviewed the petition. The court is considering whether the purported quitclaim deed transferred the property before Mr. Bennett's death, she said. The court is not deciding the family's entire history. Victor's attorney stood first. He argued that the deed expressed Elias's intent and that technical problems in the notary block did not necessarily erase the transfer. He said Elias could have signed a draft outside Patrick's office and that the document's location might have been entered incorrectly later. At most, he said, the evidence may show a clerical problem. It does not show that my client fabricated a deed. Lena answered by doing the same in reverse. We are not required to prove every possible act of misconduct in order to show that this instrument was not executed or notarized as represented, she said. The document's legal effect depends on what it is, when it was signed, where it was signed, and whether the named notary performed the act. When the deed was marked, both sides agreed that it purported to transfer the house from Elias to Victor. The dispute was execution, whether it had actually been signed, acknowledged, and completed as claimed. The first exhibit was the deed itself. March 14, 2024, 3:15 p.m., Patrick Vance's office. The second exhibit was Elias's hospital record. Lena called the record's custodian, who explained the entries without embellishment. Elias had been admitted the day before. From 2:40 p.m. until 5:10 p.m. on March 14, he was in monitored cardiac care. Victor's attorney questioned the custodian. Does the record say Mr. Bennett could not hold a pen? It records his treatment and location. So you cannot say he never signed anything that day. I can say he was recorded in the cardiac unit during the time listed on the deed. The lawyer had made his point. Hospitalization alone was not magic proof. It was a conflict with the deed's stated place and time. The third exhibit was Patrick's journal. Patrick took the witness stand in a dark suit that seemed too formal for his narrow shoulders. Lena asked whether he had notarized the deed. No. Did you affix the seal shown on the deed? No. Is there a journal entry for Elias Bennett? No. Was your office open at 3:15 p.m. on March 14? No. It was closed from noon through the next morning. Victor's attorney stood. Mr. Vance, do you ever perform mobile notarizations? When properly scheduled? Could you have forgotten one? Not this one. My journal contains no act. I did not sign this document. I did not affix this seal. You are certain? Yes. Could someone in your office have used a form containing your information? They could have used a form. They could not honestly create a notarial act that I did not perform. The judge made a note. Patrick returned to his seat. His journal answered the narrower question of whether the named notarial act had happened. It did not identify Victor. But Victor's attorney had been right about one thing. The court still needed to understand how the attestation page reached the packet and what Victor had actually done. Teresa entered the courtroom with her hands folded tightly in front of her. Lena asked her to identify the signature page. Teresa said it was hers. She explained that she had signed it in a vendor authorization packet at Victor's office. She had not seen Elias sign anything. She had not understood that the page would be attached to a deed. Lena submitted the scan Teresa had preserved. The original packet had a vendor header, a page number, and an internal code. The page attached to the quitclaim deed had none of those elements. Victor's attorney approached the witness carefully. You signed without reading the entire document? Yes. You sent a copy of the page to Victor? Yes. So it is possible you misunderstood what it was for. I misunderstood the request, Teresa said. I did not misunderstand what I saw. I did not see Elias Bennett sign a deed. You cannot say who attached the page to the later document. I can say Victor asked me for the signed page for the house papers. The attorney held up the message export. This phrase could refer to tax paperwork. It could, Teresa said. That is why I asked him what he meant. He called me instead of answering in writing. And you still sent the page. I sent a copy because I trusted him. That was my mistake. It was not permission to use my signature as proof that I saw another man sign a deed. Lena submitted Victor's archived message through the proper foundation. It did not say, I am fabricating a deed. It said, send me the signed page I needed for the house papers. Victor's attorney objected that a message saying house papers was ambiguous, and that Teresa could not know what Victor intended when he wrote it. Lena accepted the limitation. We are not offering the message as a confession, she said. We are offering it to show that Victor requested a page which, according to Teresa's preserved packet, belonged to a different transaction. The judge allowed the message for that limited purpose. Teresa could not say what Victor intended. She could say that he requested the page for the house papers and that she had not authorized its use as proof that she saw Elias sign. The property payment records showed 2 legitimate repairs by Victor, while Elias had paid the roof, furnace, taxes, and insurance. Lena offered them only to separate contribution from title. Then Lena asked permission to introduce the recorder. Victor's attorney objected to authenticity and context. Lena established where it had been found, how it had been preserved, who had made copies, and how the original remained stored with the administrator's inventory records. The judge allowed the recording for limited purposes. The first voice was Elias. You have helped me. I have paid you for work. I have thanked you for the rest. Victor answered that the house could save his business. Elias refused. The recording did not establish who touched the deed. It established why Victor believed the house should become his, and why he had continued pressing after Elias said no. Victor's attorney argued that the conversation showed only a family disagreement. That was correct, but it gave context to the signature page request and the deed's appearance after Elias's hospitalization. Lena asked me to testify after the recording. She asked what I knew about the house, the will, and the records, not whether I believed Victor was a bad person. I described the way Elias kept receipts. I explained that the certified will had been admitted to probate and that the title history still listed him as owner before the dispute. I acknowledged Victor's 2 legitimate repairs and the fact that my father had relied on him during difficult periods. Did Elias ever tell you that Victor owned the house? Lena asked. No. Did he tell you that Victor would receive a share of the property? He told me Victor would receive an investment account and equipment. He never told me the house had been transferred. Victor's attorney questioned me. You were away for long periods during the final year of your father's life? Yes. Your uncle was physically present more often? Yes. So it is possible your father discussed arrangements with him that he did not discuss with you. It is possible. You cannot testify to every conversation between 2 brothers. No. Then your belief that your father intended the house for you is based partly on a will and partly on family assumption. It is based on the will, the title history, the records of the property, and the fact that the deed you submitted was not signed or notarized as written. He paused. You did not see your father sign the deed? No. You did not see Victor assemble it? No. So you cannot tell the court who created the document. I can tell the court that the document does not prove what it claims to prove. The judge sustained the objection and told me to answer only from personal knowledge. I nodded. I did not need to become an expert witness on every part of the story. I needed to stop filling the spaces where I did not know. After I stepped down, Lena gave the closing argument. This court does not need to decide whether Victor loved his brother, whether Morrow was present enough during Elias's last year, or whether every repair payment has been remembered correctly, she said. The court needs to decide whether this particular quitclaim deed transferred title. The named notary denies the acknowledgement. The stated location was closed. The grantor was in monitored hospital care. The attestation page came from another packet, and the person who supplied it requested it for the house papers. Victor's attorney stood for the final response. The evidence shows confusion, he said. It shows a family under pressure, a former employee who signed without reading, a hospital record that does not say Mr. Bennett was physically incapable of signing, and a notary office whose records may be incomplete. It does not show that my client personally forged a deed. The judge looked at him. The court has not been asked to decide that question today, she said. That sentence gave Victor the strongest protection he had received all morning, and it also made the title ruling harder to challenge. The court did not have to assign every consequence to the civil case in order to decide that the deed itself could not transfer the house. The judge turned to Victor. Mr. Bennett, do you dispute that these are your voice and your brother's voice? Victor leaned toward his attorney. For a moment I thought he would deny everything. Then he shook his head. No. Do you dispute the conversation occurred? Victor looked at the floor. No. The judge did not treat the answer as a confession. She asked him whether he could explain why Teresa's signature page appeared on the deed. Victor's attorney objected to the question as argumentative. The judge narrowed it. Mr. Bennett, do you have a factual explanation for the document's attestation page and the message requesting it for the house papers? Victor swallowed. I thought the page belonged with paperwork my brother had approved. Which paperwork? I don't know. It was not a satisfying answer. It was not a complete confession either. But the deed's legal problem did not depend on Victor finding a better sentence. The judge returned to the execution clause. This instrument identifies a grantor, a grantee, a date, a time, a place, an acknowledgement, and a notarial act, she said. What evidence establishes where it was actually signed? Victor's attorney looked at the file. There is no alternative location in the record. What evidence establishes that Mr. Bennett signed it? The signature resembles his known signature. Does anyone testify to seeing him sign? No, Your Honor. The judge turned to Lena. Does the petitioner have evidence that the stated notarization occurred elsewhere, or that the attestation page was originally part of this deed? No, Your Honor. Does the respondent ask the court to make a criminal finding? Lena stood. No. We ask the court to determine title and the validity of the purported deed. Any suspected misconduct belongs in a referral, not an unsupported criminal conclusion in this civil order. That answer seemed to change the air in the courtroom. For weeks, the case had felt like a contest over which person could force the judge to accept the largest story. Lena had reduced it to the smallest story that still mattered: whether the document's stated execution could be trusted. The recorder supplied context, but the title question could be decided from the execution records. Victor's attorney asked the court to leave the title question open because a separate investigation might discover who had assembled the pages. The judge answered that uncertainty about responsibility did not make an invalid transfer valid. The court must decide whether this instrument transferred the property. On this record, it did not. Had the deed transferred the house before Elias died? The answer was no. The purported quitclaim deed was not executed or notarized as represented, the judge said. It is invalid and unenforceable as a transfer of title. She explained the consequence carefully. Because the deed failed, the property had remained in Elias's estate when he died. The valid will therefore controlled the disposition of the house. The notice of lis pendens would be released after the order was entered. The status quo restriction would end. Any request for costs would be handled through a separate motion with supporting records. The judge did not declare Victor guilty of every possible criminal offense. She did not turn a civil ruling into an instant sentence. She directed the suspected document and notary misconduct to the appropriate investigative and professional authorities. Victor's attorney asked for time to review the order. The judge granted the ordinary time allowed for filing, then closed the hearing. I sat still while everyone around me gathered papers. The house had not been saved by Naomi remembering me or by the recorder. The execution records had resolved the title question, while the recording explained the fear beneath it. The final order arrived 4 days later. The purported quitclaim deed was rejected. The title restriction was released. The house remained part of Elias's estate, and the valid will directed that it pass to me. The order did not say Victor had never helped Elias. It did not erase the 2 repairs he had legitimately paid for. It separated those facts from the ownership claim he had tried to build around them. Lena filed a motion for documented recoverable costs. The request included legal aid administrative expenses, certified record fees, and the cost of preserving and reviewing the evidence. It did not include every hour I had spent worrying in the kitchen. Victor's attorney asked whether I would withdraw the motion if Victor stopped contesting the estate. I asked Lena what that meant. "It means he will not make a new claim about the same deed and will return any estate records still in his possession," she said. "It does not decide what investigators do." I agreed to that limited arrangement. Victor signed a statement acknowledging that he would not rely on the rejected deed in the estate proceedings. He agreed to provide the records he had taken from Elias's repair shop and not contest documented costs that the court determined were recoverable. He did not agree to cooperate with every investigation. He could not promise what another authority would ask him to do. That was more believable than a sudden declaration that he would confess everything and make the law disappear. The document and notary questions moved into a separate process. I was informed that the referral could take time and that I might be asked for copies of the evidence. I did not withdraw it to make the family conversation easier. I also did not describe Victor as guilty of crimes the civil record had not established. For months, I had believed justice meant making Victor feel the exact fear he had caused me. The final order taught me something less dramatic and more useful. Justice could be precise. It could say, "This deed does not transfer this house. This title restriction ends. This cost can be requested with records. This suspected misconduct goes to the proper authority." No one had to shout for the facts to become real. The cost hearing happened 2 weeks later. Victor's attorney challenged several items in the petition. He argued that some of the certified records would have been required for any estate administration and should not be charged to Victor. Lena agreed with part of the objection. The legal aid organization's ordinary work was not automatically Victor's responsibility. The judge separated the categories. Filing fees and specific certification costs connected to the deed dispute could be considered. General probate administration could not. The order did not make Victor pay for every inconvenience my father's death had created. That mattered to me. If justice meant only making Victor absorb everything I had lost, it would be another form of exaggeration. I wanted the court to be accurate even when accuracy limited what I could recover. Victor returned the repair shop records in 2 cardboard boxes. Some invoices were folded, one notebook had grease on the cover. The administrator cataloged them before giving me access. Inside one folder, I found a receipt for the furnace motor Victor had paid for. Elias had written a note beside it. "Victor helped when I needed him. Pay him back Friday." The note did not erase what Victor had done. It also did not permit me to rewrite the earlier years as if every act of help had been manipulation. I kept the receipt. The administrator asked whether I wanted the furnace reimbursement included in the estate accounting. I said yes. The fact that Victor had once been owed money should not disappear simply because he later made a claim he could not support. That decision surprised Calvin. Most heirs want every payment associated with the other side removed, he said. I want the records to be accurate. He nodded and added the receipt to the legitimate expenses. The final cost order did not transform the lawsuit into a windfall. It awarded only the documented fees and filing costs connected to the deed dispute. Victor's legitimate repair contribution remained a separate accounting item. His business debt remained his. The house did not become a prize large enough to repair every injury in the family. When the investigative office contacted me, the investigator asked for the original evidence, not my theory. Works will need the deed as filed, the original message export, Teresa's preserved packet, Patrick's journal copy, and the recorder's chain of custody notes, she said. How long will it take? I cannot promise a timeline. I almost laughed. Deadlines had governed the civil case so tightly that I had forgotten some questions moved at the speed of careful work. I handed over the records. For the first time, I was not trying to make the evidence produce a particular emotional ending. I was allowing another process to examine it. I asked the investigator whether I should send a personal account of Victor's behavior around the house. She said I could provide it if it contained first-hand facts, but she did not need a catalog of every argument. That instruction felt familiar. The civil judge had needed the deed, the records, and the title consequence. The investigator needed the document trail and the people who could explain it. My anger was real, but it was not a filing category. I returned to the house with the copies that could remain in the estate file and a receipt for the furnace reimbursement in my bag. The distinction followed me through the rooms. One wrong did not turn every earlier kindness into a lie, and one earlier kindness did not excuse the wrong. Victor asked to see the house one more time. He did not ask in the courthouse. He sent the request through the attorney, and Lena asked me whether I wanted to allow it. If I say yes, that does not mean I forgive him. You can define the conditions, she said. I told Victor he could come during the afternoon. I would be there. He would not remove anything. The visit would not change the cost petition or the separate referral. He agreed. When he arrived, he stood on the porch and looked at the repaired section of railing. Your father hated that color, he said. He chose it. I know. He smiled briefly, then the expression disappeared. Inside, the house felt smaller without the dispute filling every room. Victor stopped near the workbench. I fixed that vise, he said. Dad paid you for it. I know. The repetition was not an argument. It was the beginning of a fact neither of us could keep rearranging. He looked toward the hallway where my mother's photograph hung. When your mother died, your father called me every day, he said. When the roof went bad, I came over. When he was sick, I thought I was the one who stayed. You did stay sometimes. He looked at me. Sometimes? Sometimes is still true. He sat in Elias's old chair without leaning back. You came home and he looked at you like everything he had done made sense, Victor said. I thought the house was proof that he chose you. He chose what to do with his property. It felt like more than that. Feelings can explain what you did. They cannot make the deed valid. He lowered his head. I asked Teresa for the page. I know. I told myself it was only paperwork. I told myself Elias would have agreed if he had been thinking clearly. I told myself I was correcting what he had failed to recognize. And when he said no, I treated the no as an insult. That was the escalation he had never admitted before. First, he had believed his work entitled him to more. Then Elias refused. Then Victor's business debt made the belief urgent. Finally, he used a familiar signature page to make his claim look official. None of those steps had been inevitable. They had simply become easier to take after the previous one. "I am not going to ask you to pretend this did not happen," he said. "Good. I will return the files from the shop. And the records you took from Dad's office?" "Yes. You will not make another claim against the estate using the deed." I signed the statement. "And if the cost petition is granted, you will pay what the court orders." He looked tired. "I know." We walked through the house without touching anything else. At the door, Victor paused. "Do you hate me?" I wanted a clean answer. Yes would have been easier than the truth. "I hate what you chose," I said. "I am still deciding what I feel about the rest." He nodded. That was all the forgiveness either of us could honestly manage. He left without a hug. The house remained mine, but the word mine no longer felt like a victory chant. It felt like a responsibility I had chosen to carry. That evening, I walked through the rooms with a legal pad in my hand and made a list of what would happen next. The cost petition would be decided separately. The investigative referral might take months. The administrator still had to close the estate account. The roof needed a professional inspection. Victor's repair invoices needed to be separated into paid work, disputed claims, and items he had never actually funded. The list was unromantic. It was also the first list I had made since Elias died that did not begin with the question of whether someone was trying to take something from me. I called the insurance company the next morning. I scheduled the roof inspection. I opened a separate account for estate expenses and uploaded copies of every receipt. The house did not become whole because Victor apologized. It became manageable because its future was no longer being negotiated through a document that could not survive examination. Weeks later, after the title restriction was removed, I reopened the front windows of the house. For months, I had kept the curtains closed because the rooms felt exposed. Every official envelope had made the house seem less like a home and more like a container of facts. I repaired the porch light first. The new fixture was smaller than the old one, but it cast the same warm circle across the steps. In Elias's office, I placed the final court order beside the inventory list. The quitclaim deed was stored with the legal records. The recorder remained in its preserved case. Teresa's statement, Patrick's journal copy, and the hospital records were no longer scattered across my dining room. I had learned to keep originals protected, copies labeled, and assumptions separate from facts. I had also learned that a will was not a substitute for organized title records, clear estate planning, or early legal advice. A family can love one another and still disagree about what a promise meant. A person can believe they deserve something and still be wrong. If the documents are not clear, grief gives every old resentment room to speak. One afternoon, I reread the public recusal order. It said Naomi Brooks had disclosed a prior personal encounter and removed herself from the case to protect the fairness of the proceeding. That was all it needed to say. I kept the flood incident report in the same folder. It recorded the emergency in flat language: vehicle, weather, response time, witness statements. It did not record the promise I had made through the broken window. The report could not explain why Naomi remembered me. It could only confirm that the night had happened. That was enough. I had spent years thinking courage meant staying calm when everyone could see me. The flood taught me something different. Sometimes courage was staying beside a stranger when there was no reward for it. Sometimes it was asking for help before a problem became impossible. Sometimes it was refusing a settlement that offered comfort by requiring me to surrender a question I still had the right to ask. I kept my mother's blue mug. I kept Elias's workbench. I kept the ugly paint color he had chosen for the hallway. I made one new change. On the porch, beneath the repaired light, I placed a small table with 2 chairs. It was not an invitation for Victor to return whenever he wanted. It was a reminder that belonging required honesty now. When Teresa sent a message asking whether the house was finally settled, I told her the title was clear and the other process was separate. When Lena called about the cost order, I thanked her and asked what records she needed next. When Victor returned the last box from the repair shop, he left it on the porch without asking to come inside. That small boundary mattered more than I expected. The house did not become peaceful because everyone forgave each other. It became peaceful because the truth no longer had to fight through a false document every time someone entered the room. Naomi's recognition changed the procedure, the records changed the case, my choices changed what happened afterward. Victor had helped my father and felt overlooked. Neither truth made the quitclaim deed valid, and neither required me to become cruel. I did not know what the separate investigation would decide. I knew accountability meant returning what was taken, accepting what the court ordered, telling the truth about the page, and allowing consequences to belong to the proper process. Forgiveness, if it came, would be a choice, not a document Victor could file. The house kept making ordinary demands. A pipe needed attention. The back steps needed sealing. The blue mug chipped at the handle. None of those things cared who had won the case. I began keeping a second notebook beside Elias's old one. Its first page said only, "Facts first, feelings second, boundaries always." Until then, the porch light stays on for me, not because anyone is entitled to come home, because I am.